guys, welcome back to the channel. I am Prakriti and today we are going to move further with our remaining part of the topic of negligence in the law of tort. In the last video we have discussed what is negligence, what are the essential of negligence. In the essential of negligence we have discussed the duty and the duty to whom. The other essential is reasonable foreseeability or injury. Reasonable foreseeability or injury, that a prudent person can foresee that if he don't do or do something which could damage to other person and he don't do that duty, that is amount to a negligence. So in the case of Glasgow Corporation versus Muir in the year 1943, the facts of these cases were a group of children were having a day out with their Sunday school. They were meant to be having a picnic, but the rain had ruined it. The leader of the trip asked the manager of a tea room run by Glasgow Corporation to allow the children to have their picnic on their premises. She agreed and the group entered. In the tea room, there was a tuck shop, the window to which was located midway along a corridor. The children all had started to line up along the corridor to buy sweets at the tuck shop. At this time, a large tea urn was being carried along the corridor by two adults to the main room of the tea room. The hold of the one of the bearers slipped and tea was slipped and scalded several children. Muir was one of them. The parents of the girls sued Glasgow Corporation, claiming that they owed the child a duty of care and they had breached this duty. They could held that the manager is charged owed a duty of care, generally to everyone in the tea room. However, she did not owe a duty of care to the Sunday school to take additional precautions to prevent being injured as a result of her allowing them to enter. So long as the tea room was run in the same manner as it was day to day and the same safety standard, she was not required to take extra steps to prevent the incident which occurred. It was not reasonably foreseeable that allowing the children to come into the premises would result in one of being them scalded. As such, the incident was put down as an accident which could not have been prevented. Lord Macmillan said in this case that legal liability is limited to those consequences of our acts which a reasonable man of ordinary intelligence and experience so acting would have in contemplation. The duty to take care is the duty to avoid or omitting to do anything or omitting to do which may have it is reasonable and probable consequence injury to others, and the duty is owed to those to whom may reasonably and probably be anticipated if the duty is not observed. In the whole case, I hope you have seen what is the reasonable foreseeability of injury. In this case, it was clearly said by Lord Macmillan that the defendant was not held liable because the day-to-day affairs in that tea shop was going on and the reasonable care was going on. The owner cannot foresee that an accident would happen and the child whom she have permitted to enter in her tea room, in her cafe premises, would be scalded by the accident by one of her workers. So the court didn't hold her liable. The court didn't hold defendant liable for the negligence because the reasonable care which for a foreseeable event was already been taken care. And Lord Macmillan said that the person is liable only when an ordinary intelligent person or with his experience is taking every duty and every care of commission and omission of the act, then the person is not liable to held for negligence. And in the case of Borwell versus Young, the plaintiff, a fishwife, alighted from a tram car. While she was being helped in putting her basket on her back, a motorbicist, after witnessing the tram collided with a motor car at the distance of 15 yards on the other side of the tram and died instantly. The plaintiff could see neither the deceased nor the accident, as the tram was standing between her and the place of accident. But she had simply heard about the collision, and after the dead body had been removed, she went to the place and saw blood left on the road. Consequently, she suffered a nervous shock and gave birth to a stillborn child of 8 months. She sued the representatives of the deceased motorcyclist. It was held. These are the facts of this case, and what was held? It was held that the deceased had no duty of care towards the plaintiff, and hence she could not claim damages. The lady, for the stillbirth of her child, claimed compensation from the deceased of the motorcyclist representatives. But court held that the deceased motorcycle have no duty towards that lady because there was no direct contact between them. There was a truck between them. And the third essential is duty must be towards the plaintiff. It is a very important essential that it is not sufficient that the defendant or the duty to take care. It must also be established that the defendant or the duty of care towards the plaintiff. According to the duty to whom, it is a part of that the duty must be towards that plaintiff. The defendant have the duty, but whether the duty was against the plaintiff or not, that must be proved by that plaintiff. Breach of duty to take care. Yet another essential condition for the liability in negligence is that the breach of duty to take care or he failed to perform that duty. That the defendant, the person have the duty to take care, and the essential to claim for negligence is the person who have the duty to take care have breached the duty or have been failed to perform that duty. In the case of Municipal Corporation of Delhi versus Subhagwanti, AIR 1966, a clock tower in the heart of the Chandni Chowk, Delhi collapsed, causing the death of a number of persons. The structure was 80 years old, whereas its normal life was 40 to 45 years. The Municipal Corporation of Delhi, having the control of structure, failed to take care and was therefore held liable. So, it is clearly can be mentioned in this case that the municipal corporation have all the duty related to that structure which was fallen down, and it was foreseeable event that the lifespan of this building is already 40 to 50 years and 80 years has been passed. So the building needs some changes or some care, and the duty has been failed by that municipal corporation, and thus they held liable. The another essential is damage or harm to the plaintiff. The very important essential which should be established by the plaintiff. The plaintiff should prove that due to the breach of the duty by the defendant, the plaintiff have damage or harm in any way. The last essential requisite for the tort of negligence is that the damage caused to the plaintiff was the result of breach of the duty. The harm may fall into following classes. The harm which has caused to the plaintiff should be a physical harm, either harm to reputation or harm to property, land and buildings and rights and interests pertaining thereto, or any economic cause, mental harm or nervous shock. The damage should be proved by any of the 5 harms should be